SwayamPrabha. Digital India. Educated India.
Welcome back to the lecture 3 of Law of Torts, Consumer Protection and Motor Vehicles. I am Dr. Anirban Chakravarti, and in this lecture we will discuss the very interesting aspect of capacity to sue or be sued. Now, when we say sue or be sued is very conventional or traditional, a lawyer's term. In simple language, it means that who can file a case or against whom a tort case can be filed. This is basically the simplistic, in common man's language this means. So, who can be a party or against whom a tort case can be filed and who can file a tort case. The topics that will be covered in this lecture will be following. At the beginning, we will see whether the minors or the person who are below the age of 18, they can be subject of tort cases. So, whether they can file a tort case or a tort case can be filed against a minor. Mentally unsound persons, though persons who are in today who are not having the having some challenges or some kind of issues with relation to the mental soundness, whether they can be part of our tort proceedings. And alien enemy. Alien enemy means a party is a national of a country against whom India has declared war, or that particular country has declared war against India. So, a national of that country is called an alien enemy. Second category, we will see about corporations or companies, whether they can be subject of tort proceedings. Third is state. State means the government. So, the government, whether it can be party to a state tort litigation or tort proceedings. Lastly, with reference to state's liability in torts, we have seen in our earlier lecture that there are two types of divisions, the private law and public law, and private rights emerging from private law and public rights emerging from public law. So, similarly, private law remedies, public law remedies, they are a classification existing in law. So, tort is usually considered as a part and parcel of private law system, whereas constitutional reliefs, remedies, crime, they are considered as part of public law or public law relating proceedings. Now, tort usually was never considered as part of public law. Tort was considered as a part and parcel of private law relief. However, in current context, there are some decisions where through the public law remedies, tort proceedings have been considered, and in these proceedings usually the state has been a party. So, state has been the violator, and in certain conditions public law proceedings, tort violation of state or its servants have been considered and public law reliefs have been granted. So, what are the provisions and what are the mechanisms by using which the courts have granted these public law reliefs to pure private law violation, or similarly a private law subject like tort is an interesting aspect of development, and Indian Supreme Court has been spearhead of that development. So, we will study that also. So, these are the four principal topics that we will cover in this particular lecture. Now, as I said to begin with, the word sue and sued is traditionally or conceptually a very what we say legal terminology. But in common parlance, the equivalence or synonym will be filing of cases. So, whether a person can be subject of a proceeding of that nature or a case can be filed under that branch of law against that person or not. So, when we say that whether a minor, so minor, the word means that a person who has not attained the age of 18 years as per the Indian Majority Act. So, there is a law which applies, which calls the Indian Majority Act, and the Indian Majority Act says that any person who is below 18 years of age is a minor. Now, a minor, whether he can be subject of tort litigation. Now, when we say subject of tort litigation, it can be both sides. He can also file a tort litigation. So, whether a minor can file a tort litigation. If yes, what are the conditions? If no, then why? And secondly, can a tort litigation be filed against a minor? Whether all types of tort litigations can be filed, are there any conditions? So, that is something that is dealt by this aspect of capacity, or what we say who has the legal against whom in law a litigation under that particular type of branch can be filed or can file. Now, as far as general norms, with reference to the branch of law called torts, there is not any large modification or exceptions or provisions against who can file or who against whom a tort proceeding can be filed. Almost everyone is a subject or can be a subject of tort litigation and can also file a tort litigation. However, there are some conditions or some exceptions. But to understand capacity better, we can take some illustrations from law of crime or law of contract. Now, say in law of crimes, it is prescribed in the Indian Penal Code. Of course, now it has been replaced by the new code which has been adopted from the year 2023, though it has not come into force, but we have now adopted a new criminal code, a new procedural law replacing the Code of Criminal Procedure, and a new Evidence Act also. Now, in this the sections may vary, but as per the earlier Indian Penal Code, in the chapter called General Exception, it was very clearly stated that a person who is below 7 years of age, try to remember, a person below 7 years of age cannot be subject of crime. So, if a person below 7 years of age commits a murder, what, forget it, whether possible. Hypothetically, let's presume that a person below 7 years of age commits a murder. That person will not be subject of any proceeding, because there is a common law theory called dolly in capax, means a person below 7 years of age is incapable of commit a crime. The simple reason is that crime requires mental element. So, there has to be some motive, some mens rea, some intention behind committing a crime. Crime cannot be just an act. Okay? Now, for that you need certain kind of a maturation or cognition of the brain, and a person below 7 years cannot have that maturity or cognition. Even if a person below 7 years for some reason commits a crime, it will not be because he had a motive, intention or reason to commit the crime. It must be an accidental or somehow he got involved. So, therefore, he is just exonerated due to the theory of or by the virtue of theory of dolly in capax. Between 7 to 12 years of age, this general waiver is not allowed. It is not generally completely exonerated. However, majority of cases will be exonerated unless it is found that the person has a mental ability to understand the consequence of this act. So, if he has thrown a stone and he has the mental capability to understand that when he is throwing the stone may hurt somebody, may injure somebody, and still he throws the stone, then in that case, if that person who is between 7 to 12 years of age, if it is found that that person has that mental capability, then that person can be subject of criminal proceeding, although separate, not criminal, it is called juvenile justice. But below 12 years, below 7 years, no such question. 7 to 12 conditional, 12 to 18 juvenile justice, but full criminal culpability, and 18 onwards he becomes the subject of adult. But in torts there is no such differences. In torts, any person can of any age be subject of tort litigation. Of course, there are some conditions, but largely there is no restriction, and the reason is that unlike crime, torts does not require any mental element, and neither tort affects somebody's liberty. There is no punishment, it is a payment of compensation. So, in case if it is found the minor is guilty, the father or the parent or mother or the family is somewhere through which the compensation is recovered. And similarly in contract, minor is also exempted from incurring into contractual liability. So, again person below 18 years of age simply if files or signs in a contract, the contract is considered void ab initio, void from the beginning. Now, this word void ab initio is important because when you study contract act or any other law for some reason, if it is said void, it means that at some point of time, maybe from the beginning or maybe at some point of time during the transaction, the document has become illegal, ineffective, or nullity, annulled. However, if it is said void ab initio, that means that document has never come into force. There was never any legal force to that document. So, a minor's contract or a minor entering into a contract as per Indian contract law is considered as a void ab initio. So, therefore, you can see generally already the distinction between tort and crime or contract with reference to the capabilities or capacities to sue or be sued by minors. So, as I said, in torts, in terms of liability to be sued or capacity to sue, for minor there is no special provision, and largely it is considered that any person of any age can be a subject of tort litigation for or against. However, age has to be taken into account when any mental element such as intention, malice or negligence on his part is relevant for deciding his liability. Now, there are some torts where mental element is required, for example fraud, for example the economic torts. Now, when mental element is required, then in such case of course the capability of the child's brain or his cognitive understanding will be questioned, but otherwise there is no question about the minority as a defense or minority as a claim or as a bar against filing a suit. Now, as I said, the parents will be also held liable at times if the minor is not able to pay, or the minor is liable but is not in a position to compensate. In the case of Vela Pandit versus Manik Thai in 1970 in Madras, it was held that a father of a guardian is not responsible for torts of a minor. So, not always, however, the parents can be held responsible. In limited cases, parents can be held responsible where it was directly the negligence of the parent, the minor committed the wrong, or very well the parent knowingly overseeing the minor and the minor still doing the wrong. But in some cases where it is completely an independent transaction and the parent had absolutely no idea, then in that case it may not happen that the parent be held responsible for that reason. but in circumstances of cases may be such as to constitute the child the servant for the time being of the father, in which the case father may be liable. Say if X is Y's child and X takes Y's car when he is not having an age of having a driving license or driving vehicle in public road, takes the car and drives and causes accident. Then in that case the father of the child or X will be held liable, because at that point of time the child was actually involved in the transaction in a relationship which we say vicarious. So if it's a vicarious liability, when we discuss types of liability, we will discuss vicarious or secondary liability, or two persons jointly become liable. You can say a form of a joint liability also. Then in that case, if there is a vicarious liability, of course the father will be liable for the child. Now when it comes to minor, another very important aspect is that one is post-born rights, another is pre-born. So when a child is not yet born, he is in the state of prenatal, or when the child is in the womb of the mother. Now at that stage, if there is some kind of a wrong which is a wrong of nature of torts, then the child also incurs the right to sue for that kind of an injury or that kind of a wrong. Now a question of this nature came before the court in the case of D. Matrell versus Martin and Sutton Health Authority 1991. It is an English judgment of the Queen's Bench Division. In this case the argument was that whether a minor can sue for a prenatal injury, and the hospital said that if that injury has been of prenatal nature, then post-born there was no injury, even if they admit that there was an injury of a prenatal nature. However, the court said that minor can sue for all torts committed against him like any other person, except that he has to bring his suit through a next in friend. And secondly, the preponderance of authority now is that minor can also sue for prenatal injury. I will come to this point next in friend in few minutes, but before that let me just address this prenatal thing. So it was said that prenatal injury can be also part of a proceeding brought by minor. Now the question was in this case that when an injury, the time of infliction is not when the minor has born, then in that case whether legal personality has restricted application, and a fetus is not a legal person from the very point unless he is born. However, the court held that it is agreeable that the fetus has no legal personality in this case. However, the cause of action that of the injury that fetus had incurred and in its prenatal stage also continues after his postnatal or his antenatal or his birth. So therefore, the child, if it is born deformed due to some fictional or functional aspect of negligence in the healthcare facility, then the child has right to file a suit in a antenatal or post-born stage. The only exception in this case is that if, knowing that there can be a possibility of a child born with a particular risk, yet the parents of the child incurs that liability by a preconceptional agreement. So the doctor said that the child may born with some kind of a physical deformity, and still the parents agreed that we will have the child birth, and the child born with the deformity filed a suit later on to the hospital that why did you, if you know that I was going to be born with this deformity, gave birth to me, because now I am a burden to myself and to the entire world, and I am not able to enjoy all the aspects of human life and liberty. Now in that case the hospital has a defense that we had explained to your parents, but they wanted to give birth to you, and therefore we are not liable. Otherwise, if the injury is caused due to negligence of the healthcare authorities, then the healthcare authorities cannot defend themselves. Now coming to this question of next in friend, this is one condition that when a minor is either sued or is suing. Now minor does not have a legal personality, by virtue of the fact that minors cannot contract, Indian Majority Act, minors cannot contract. Hence minors, always in a suit is represented by his guardian. If there is no legal guardian or natural guardian, then somebody court appoints as court appointed guardian, or somebody the court appoints as next in friend. So in our normal civil law, we call next in friend who is representing the minor, or taking the decisions for the minor with reference to the litigation. Now with reference to these prenatal injuries, the position has been now upheld in India also. We all know the effects of Bhopal gas tragedy that happened in India, one of the worst industrial disaster in the entire world. And we know that even after the tragedy, it's not that on that night or sometime very close to that only people suffered. The effects of this toxic gas that got mixed into the environment is still felt. So there was a newspaper reporting in 1995 in June in Empire Chronicle, a report, a journal or a newspaper, that 30 children were found suffering from congenital heart disease because of toxic effect of the gas on their mothers. So these 30 children, they were either their mothers were pregnant at that point of time, or or they were just conceived. And because of the toxic gas and the impact on the mother, these children are still suffering with congenital heart disease, or congenital means born with that disease. And when the matter was referred to the Supreme Court bench in Union Carbide Corporation versus Union of India case in 1992, the Supreme Court, upholding the English law, held, and I quote, "Those who were yet unborn at the time of Bhopal gas leak disaster, who were able to show that their congenital defects are traceable to the toxicity from the gas leaked, inherited or derived congenitally, will be entitled to be compensated." So it is clear recognition by the Supreme Court in Bhopal case that congenital issues, if it is caused by negligence or this kind of major mass disasters, they can be compensated, and the persons can file such cases. Now same with unsound mind. Similarly, IPCN contract, as it exempts minors, there are certain exceptions or exemptions applicable for unsound mind persons also. But in torts, there is no such case involved, as mental element in torts is very limited. So in Tyndall versus Tyndall case, it was held that generally, unless the degree of insanity is of such grave nature, the defendant is unable to know the nature of his act, he would be liable in tort. So the mental insanity or mental unsoundness is of such nature that it is difficult for that person to comprehend what he is doing, or the tort is of such nature that requires pure intentional or mental element, which is impossible for a person of unsound mind to be formed. Rest all cases, a person of unsound mind can be held liable for. And there are cases where person of unsound mind has been held liable, such as in Morris versus Marsden in 1952, a person with unsound mind was held liable for assault cases. Assault case does not either require a such kind of mental understanding, or there is no wrong or intention involved in it. Third is alien enemy. Now in contract, again exception is given in alien enemies cases, that alien enemies cannot enter into a contract. Now as I said, who is an alien enemy? An alien enemy is a person or enemy nationality, or a person residing or carrying on business in an enemy territory, whatever his nationality. So enemy territory does not mean that it has to be always an enemy territory. It may be an enemy territory declared at some point of time, or it may be an enemy territory at a later period of time. So any person who is residing, or a citizen, or a national, or carrying business in an enemy territory is considered as an alien enemy. And it doesn't matter what is his nationality. So he may be a Bangladeshi and he has his current residence and business in Pakistan, but is currently in India, and India declares war with Pakistan, then that person will become a alien enemy, although he is Bangladeshi, but mainly because his business is in Pakistan and he is in India with connection to the business. So basically India, Pakistan, no business can happen, no contract can happen because it has been declared an alien enemy. So alien enemies has very limited right to sue or be sued. However, in torts, the general rule applies, which applies in a limited way for all other civil proceedings. Alien enemies residing in India with the permission of the central government. So if the central government permits this person, he may sue in a court otherwise competent to try a suit as if they were citizens of India. So when an alien enemy is residing in the India with the permission of the central government, then that person has a right to sue like a normal citizen. But alien enemies residing in India without such permission or residing in a foreign country shall not sue in any such court. So if that person is an alien enemy who is residing in India without such permission, or he is a person who is residing in that territory of the foreign country or any other foreign country, that person cannot sue, and the rule that applies here which prescribes this is section 83 of the Code of Civil Procedure of 1908. Now moving further, another very important category comes is husband and wife. Now normally this may not be a question of debate, why husband and wife, because they are two different living individuals. But in our traditional conventional common law, husband and wife was largely seen as one and same person. So in terms of legal personality, common law did not divide it between them in terms of the responsibility and liability. Rather it went a very, it's not a correct notion, it's a very wrong notion. But yet, common law said that to some extent the wife is the chattel of the husband, and there were provisions. Now slowly those provisions are removed. So in orthodox common law position in England, a married woman could not sue for any tort committed by a third person unless her husband joined her as a plaintiff. So when there is a liability incurred by a third person against a wife, a woman, forget wife, a woman, and that woman is a married woman, that woman cannot file the case against that third person unless the husband joins with him as a co-plaintiff or a co-suitor, right? Secondly, married woman could not sue for torts committed by her unless her husband was made a defendant. Similarly, a married woman cannot be sued. So A, married woman cannot sue. Second, the married woman cannot be sued unless the husband is also made a defendant. Third, married woman could not sue her husband, and the husband could not sue her for any tort committed by one against other because they were considered as the same person. So as I cannot file a suit against me, similarly a husband and wife, though they are technically or all meaningfully biologically two different individuals, in the eye of the old orthodox common law they were one person. So there is no possibility of suing against each other. As I said in my first lecture, that it has been very since beginning and has become categorical in India post independence, that although tort has a imagined to be largely an impact of English law or has been an effect of the English law, yet it's not that all English tort law principles are to be applied in India as it is. So in this case there has been a clear change in the position. In several cases the courts have observed that in India we have never seen the husband-wife as a single personality or entity. Marriage has no effects on the rights and liabilities of either of the spouses in respect of any tort committed by either of them or by a third party. So they are not one, and there is no kind of an effect on the rights and liabilities individually with reference to a third party. Similarly, wife can sue the husband for any tort committed by him against her, and the husband can sue the wife for any tort committed by her against him. Wife against whom a tort has been committed by another person can sue him without joining the husband. So exactly what is the English position, Indian position is quite different or contrary. Now let's move to the another new category, which is corporation. Now, or company. Now a corporation or a company is also quite unique. Now why it is? Because the most important advantage of being a company is having a legal personality. Company is treated like a normal person. It's called a juridical person. So a artificial person, so a deemed personality is imposed. So company is a legal person, and therefore like any legal person, company can sue and be sued. However, corporations cannot obviously bring a suit for torts which are only wrongs against living person. For example, false imprisonment. Now, it is not possible to file a suit against a corporation for false imprisonment, because a corporation cannot falsely imprison. Its employees can falsely imprison, vicariously it can be held liable, but individually a corporation cannot be held liable for a wrong or tort like false imprisonment. Corporation can sue a libel charge if it was insolvency or with dishonest incompetent management. So corporation can sue a libel charging it with insolvency or dishonest incompetent management. Similarly, corporations like living persons have reputation. So if tomorrow somebody says Jio is an insolvent company or Jio is a dishonest company, then in that case the incompetent or run by incompetent management is going to affect his reputation in the market. Hence, the management of Jio can file cases. Similarly, vicarious liability, what I said, it's kind of a secondary liability. Corporations can acquire liability vicariously. So the servants of the company can commit some wrong, which can be even in the nature of direct torts like false imprisonment or assault. In that case also the corporations can be held liable, and they can be held liable through vicarious liability. So negligence of a driver committing a road accident. Now the bus belongs to the UP State Transport Corporation. Now UP State Transport Corporation can be also held liable for the negligent driving of its servant, the driver in that case, by vicarious liability. So vicarious liability can pass, and through vicarious liability a corporation can be liable for all types of torts like negligence, imprisonment, false imprisonment, trespass, libel, conversion, all types of. But there is one question, that can corporations be held liable for those torts which require mental element or where some amount of malice is required, for example fraud or for example conspiracy. Now there a very interesting doctrine has been used to impose liability. This doctrine is called the doctrine of alter ego. In simple term, it means that a human personality has two sides. There is one side which we can always see, and there is the inner side. Now the inner side also sometimes governs us, and that is called our alter ego. Now this inner natural side or inner alter ego, when it takes sometimes certain decisions, then in that case sometimes we are held to be bound or responsible. Now in case of companies also, it has been held that through using this alter ego, that it's true that company is not a living person, so company does not have a mind or brain of itself, but its management who are directly in the control of the day-to-day operation or control of the decision making does have a mind and brain, because they are all natural persons. So ultimately, if a fraud is committed which is directly linked to the management, then the alter ego or this company's management can be held liable. So that injustice is not left unremedied. So therefore, in Lannett's Carrying Co. versus Asiatic Petroleum Coal Limited, it was held that a corporation is an abstraction. It has no mind of its own any more than it has a body of its own. Its active and directing will must be consequently sought in the person of somebody who for some purposes may be called an agent, but who is really the directing mind and will be the corporation, the very ego and the center of the personality of the corporation, the management. So therefore, by extending the alter ego doctrine, the management of the corporation has been held liable. Now moving further, we come to the most important, exciting, interesting part of this lecture is a class which is called the state or the government, where the state and government can be held liable for wrong of torts. Now, we saw through our discussion till now minor, unsound mind, alien enemies, corporations, husband and wife, all these categories. There was a question initially whether they can be held liable or not, but over times addressed and the answers have been provided. So similarly, with reference to state also, a development has happened, a very interesting jurisprudence has developed, and it is a very central aspect of modern days torts, that to what extent the old doctrines or the old principles of common law torts can employ with the modern governments or dealings of the modern government in reference to torts. Now, we will start with the principle which is called in common law as king can do no wrong. King can do no wrong. Now, that is very interesting. What does this mean? This means that king can do no wrong. Okay? Now, does that sound very natural or very wise that king can do no wrong? Because we say principles of rule of law, law is above all. The Indian if we say Indian equitable, equally to rule of law, the concept of dharma, which says dharma is above, king is below dharma, then where does this come? This term king can do no wrong comes. Now, the king can do no wrong is actually an exception principle. What does its original theoretical meaning stands? Now, say there are two territories A and B. A is ruled by king A and B is ruled by king B. Okay? And now king B declares war against king A. Now, among the various important functions that the king is supposed to dispose by capacity of being king is to defend his territories, to ensure the physical safety and security of his territories and all his citizens. Now, when B declares war against state A, now A has to defend. Now, defend means A has to move his soldiers to the front where the war will be fought, or where the other side soldiers have come or probably entered through. So, they have identified, it may be multiple places also. Now, the army is located in a particular place. Now, the army has to move. Now, army moving means like it's not like few persons are moving, it's a whole machinery. So, army will move in old days with elephants, cannons, now with modern technology. Similarly, modern ammunition, arms and war machines. But the movement is same. And in this process of the movement, there will be some kind of destructions of private properties which comes on the way. So, if there is a road that needs to be built for the purpose of strategic movement of certain ammunitions or war machines, and there is a house that is coming in between, the house has to be demolished, and the people of the house has to be evacuated and given some alternative accommodation or alternative place of stay. Now, all this happens, the war is fought, and the country A led by king A comes victorious over country B led by king B. Now, country A comes into peace, agreement is signed, armies and all other sort of strategic military interventions are resolved, they leave the country, everything is back in normalcy. Of course, the army also moves from wherever the fronts to its places where it is usually camped or where it is usually staying. Now after all this, now those private property owners whose houses were demolished or whose properties were demolished or damaged, they start filing cases in the court saying that now king gives us compensation. Now is it fair? Because king did not destroy or damage the property for his personal amusement. It was for the purpose of defending the country, and defending the country is a sovereign function. Hence, when it comes to discharge of sovereign function, the state or the king was held to be not liable for any wrong. So the rule that emerged, king can do no wrong, it meant that not that the king is always above law or king is always above everything. It meant that in certain types of dischargement of function, if the king commits certain wrongs or king commits certain acts which are equivalently, if committed by a normal person, would have been compensated or would have been held to be wrongful acts by the courts, with king it will not be held, because they are part and parcel of discharging of the sovereign function. However, the question always was that it is not with all types of functions, only limited to sovereign functions. Now what is sovereign and what is non-sovereign, that has always remained an important matter of legal debate or dispute. And the first case to that extent which we see in Indian jurisprudence in torts in connection to this is the landmark judgment decided in 1868 by the High Court, the Supreme Court of Calcutta, Peninsular Oriental Stream Navigation versus Secretary of State of India. Now this Supreme Court is not the Supreme Court of India currently, it is an old colonial court established under some British statutory or charter, and that court decided this case, yet this case is of great relevance globally. Now in this case, what factually had happened was that in the port area of Khidirpur of Calcutta, there was a warehouse, and in the warehouse belonged to the East India Company, and its servants were actually moving some big iron plates or iron rods or iron features, whatever you say, from one part of the road to other part of the road, and through an overhanging crane or a pulley crane. Now below the road, the horse cart of the plaintiff was carrying some person and some property of the plaintiff. Suddenly, due to some negligent, intentional or unintentional act, there was a certain accidental break of the crane and the entire mass fell on that plaintiff's carriage, which damaged the carriage permanently and causing some loss to the plaintiff. And the plaintiff filed a case for recovery of damage. Now in that case, the state defended through the Secretary of State of India, saying that it is a sovereign function, that the state's employees were engaged, and hence this case cannot be heard by the court. It falls within that category of sovereign function where state is exempted from any incurring liability. Now to look into that, what the court did was first took up the statute which created this particular state of India at that point of time. Like we have today the independent state of India, whose main creation is the Constitution of India. So, the Constitution of India discusses about the entire mechanism, administration of the state of India. The time when we are referring to, it was a Government of India 1958, which was a act which of the British Parliament which established the state of India at that point of time. Now, in section 65 of the Act, it was stated that all persons and bodies politic shall and may have and take the same suits, remedies and proceedings, legal and equitable, against the Secretary of State of India as they could have done against the said company. Now, this was a very interesting provision, and the question was that then all suits, everything which can be proceeded against the predecessor of this English state, the East India Company, could be taken against Secretary of State. Now, the question that argued was that the state now and the East India Company are not the same. This is now a Queen's direct proclaimed state of India under the sovereign of England, and that was an East India Company which was largely a trading company with some limited rights granted by the Queen to establish with certain sovereign function, vested with certain sovereign function. However, they were equated, and whether this equation is correct or not. So, the legal question that the court had to answer in this case was whether for such an accident caused by the negligence of its servant, the Secretary of State for India will be liable or not. Now, addressing this question, the Chief Justice Peacock, who was delivering or concluding the judgment of the court, held that in determining the question whether East India Company would be under the circumstances having liable to an action under the general principles applicable to sovereigns and states, and the reason deduced from the maxim of the English law, king can do no wrong, would have no force, because East India Company was never a sovereign. East India Company is not a sovereign. East India Company is a trading company with some limited right. So, therefore, when the state which has now been formed in India, where the statute has equated it with East India Company, it is also a limited sovereign. So, therefore, the discharge of its function is limited function, and hence there cannot be considered as a sovereign function, hence the government is liable to compensate, because it is a non-sovereign function. So, the test that was implied, that whenever a case of question of sovereign or non-sovereign arises with reference to state in question, the test that will be applied by the courts are following. 1. If a wrongful act or omission is committed by the servant of the state or government in exercise of sovereign powers, the state or the government will not be held liable in tort. Similarly, the tort in case of peninsular oriental steam navigation was committed by the servants of the government in course of trading activity, and hence the case was not directly concerned with the act done in the exercise of sovereign function. So, it says that this dockyard maintenance or removal of its things, they all fall not within the sovereign but what we call non-sovereign function, and hence a non-sovereign function is not protected under this doctrine. What is protected is only sovereign functions or political functions of the state. Now, defending a country is part of a political or sovereign, you can say. Political function would not be right term. You can say that particular functions of the state which is for which the state is constituted. But state also disposes many other functions. For example, commercial or economic functions. Now, where commercial or economic functions are purely like a trading company, like BSNL company, which is a public owned company. Now, if BSNL says that any wrong committed by us or my servant is exempted, now that cannot happen. So, therefore, it is no more a sovereign function. So, that exclusion comes, and that exclusion is applied in every cases or every scenario where this question has arisen. Now, one need to also understand that the implication of this case or this issue did not stop with only pre-independence time. In post-independence, in Article 300, the Constitution of India has equated a similar provision as we discussed in Government of India Act under Article 301, putting the state exempted for sovereign functions. And today the state has multifacet functions. Today the state is doing everything. So, therefore, to what is sovereign and what is non-sovereign has been a matter of large debate. And we have some very leading cases in India post-independence time where this question has been discussed, starting from State of Rajasthan versus Vidyavati in 1962, then Kasturi Lal versus State of UP in 1965, then Nagendra Rao and State of UP in 1994, then Andhra Pradesh versus Chella Ramakrishna Reddy in 2000. These are some landmarks. There are many more. Now, I will discuss one or two just to help you to understand. State of Rajasthan versus Vidyavati, in this case the the vehicle of the district magistrate went for garage to repairing, and when it was coming back it met an accident. The person filed a suit claiming compensation. The wife of the deceased in the road accident. The state claimed protection under sovereign immunity. The court held this is not a sovereign function, and hence there is no exemption. However, in the next case there was an alteration of the issue, and the alteration was very interesting and a very unlikely departure, and probably the only departure in the entire Indian jurisprudence on this is the case of Kasturi Lal Raila Ram Jain versus state of UP. Now, in this case, one gentleman who was a trader of gold and silver went to one place with a good stock of gold and silver, but because of certain legal regulations he was arrested and he was taken to the police, to the thana, and there all the gold and silver stock that he has was recorded in a book and was kept with the malkhana. Now, after a point of time he was released, and when he asked for the release of the stock of gold and silver which is in the malkhana, it came to the notice that the police constable who was in charge of the malkhana has left with such precious precious things which are all in the malkhana to Pakistan. It was independence time, has left to Pakistan and non-traceable, and therefore now nothing is there in the malkhana to return. Very limited things were returned. So, Kasturilal filed a case saying compensation for the loss. Now, again the state pleaded the defense. Now, in this case court held because the police was discharging sovereign function of maintaining peace, security, and the transaction happened in course of that, then it comes within the sovereign domain and it is regarded as a sovereign function, hence the state's exemption was granted. But the logic that was provided by the court in this case was not very well accepted or well taken by the entire community, and almost everybody wrote critically. However, this is the till date the highest number of judges bench of Supreme Court which has looked into this matter, and hence we cannot completely ignore this case and its precedent, because we are a common law country and we are ruled by a decision given by the highest number of Supreme Court judges. In the line of precedents that have been discussed with reference to state liability, Kasturilal remains the case with highest number of judges deciding, and there it has held this police arrest or police absorbing goods at times of arrest on taking to malkhana, and if the goods are lost in the malkhana in course of those transactions, the state cannot be held liable as it is part of sovereign function. But in Nagendra Rao, where a similar sort of situation happened with sale tax authorities, the Supreme Court in 1994 did not accept that as a sovereign function and said that nothing doing, you please repay compensation. Kasturilal was discussed, but with certain differences the Supreme Court did not overrule, because it did not have the power to overrule as Kasturilal or a higher bench. With certain difference it did not rely or kind of differentiated itself and held that here the state is liable. Chella Ramakrishna Reddy, two person who was imprisoned where in the jail there was bombing or crude bombs hurled on them in the prison facility, and this one person died and he claimed compensation now for the death or negligence of the jail authority to provide him security. Hence, the state pleaded sovereign authority exemption. However, it was denied on this ground, and Chella Ramakrishna Reddy was asked to be compensated by the state. And this gave rise to what we saw a very new dimension. Chella Ramakrishna Reddy or the two other cases which are mentioned in your screen right now, Rudul Shah versus State of Bihar and Chairman Railway Board versus Chandrima Das, all these cases, unlike the other cases, they were cases under Article 32 of the Constitution, which we say writ petition. Article 32 is a unique feature of our constitution. It's a fundamental right where a fundamental right is violated of a citizen by the state. Now, in Rudul Shah's case, one person who was unsound mind was kept in the prison after even completion of his period and of detention without any reason or justification. In Chella Ramakrishna Reddy, we saw already, we heard hurling of bomb and killing of the person in the prison facility. And in Chandrima Das case, a Bangladeshi woman was raped in the premise of the Howrah railway station Yatri Niwas. And in every case, to some extent, there was a negligence on the part of the state or its employees. Now, all these cases were brought under 32. Now, 32 initially, as it was found to be, is a public law remedy where the court can grant writs in form of 5 writs: habeas corpus, mandamus, certiorari, prohibition and querento. But the court extended the power, saying that if we do not give compensation and if we go by technical distinctions of public and private law reliefs, then we are going to fail our constitution. So, the court said where there is a blatant negligence on the part of the state and its employee, the state cannot be exempted either under sovereign immunity or say it is a public law and you cannot give public law compensation for private law wrongs. All these technical distinctions or technical arguments will not apply. So, in these cases, state's liability for wrong in tort was even extended in public law. So, therefore, in this chapter we saw in this progression of the lectures that who can be sued and who can sue in torts. And we saw the categories and we saw how law changed, we saw how the position is now, and this gives us an idea that almost everybody now comes under the domain of tort. So, this branch of law therefore is such an important branch of law. We will proceed further in our next lecture with justifications. Till then, thank you very much for your attention and being with me. Hope to see you in the next lecture. Thank you.